order of deportation and adjustment of status. Should I go with the immigration court to file my adjustment of status application, or should I just file my adjustment of status application with USCIS? In this video, we are going to talk about this complex subject. My name is Bijoux, Ngwanda, immigration lawyer based here in DC. I do work with individuals across the country and around the world because we're dealing with complex US immigration law cases. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss anything. If you enjoy the content, again, please go ahead and share, like, and don't forget to comment below. Also, you can join me on Facebook, private Facebook group, link in the description box below, or you can follow me on Instagram because we're talking about employment-based immigration. We are really focusing on the business side of immigration. Let's get right into the topic. This is very complex, right? So the first thing first, you ask yourself, am I an arriving non-citizen? Because we no longer use the term alien, so we use the term non-citizen. So you ask yourself, am I an arriving non-citizen? I have an order of deportation. Did I or did ICE executed that order of deportation? Simply means that you never departed, either voluntarily or non-voluntarily. So if you are an arriving non-citizen, okay, and the order of deportation that was final, even though it's final, but that order was never executed, meaning that you never left the country voluntarily or not voluntarily, then the answer is yes, USCIS has jurisdiction to actually adjudicate your case of adjustment of status, provided that you are eligible for adjustment of status. Simply means that if the order of removal, right, is based on some type of ineligibility issues. For example, let's say that you filed an asylum application with USCIS, then you were referred to the court because the USCIS found out that the asylum application was frivolous, okay? Now you are in court trying to defend it, but you did not succeed and you were ordered deported. And the underlying issue of the deportation was because you filed a frivolous asylum application. Unfortunately, you cannot adjust status even though USCIS has jurisdiction, okay? Because of that frivolous thing, there is no waiver available for it. But let's say that there is the underlying issue of your deportation. You have options to have a waiver, to waive those type of issues. Maybe it's fraud, misrepresentation. Then yes, if you meet those other requirements, arriving citizen, order of deportation was final and never executed, yes, you can adjust status with USCIS and file for a waiver and hope that everything gets granted and you get your lawful permanent status. Now, this is the caveat. Once you get your lawful permanent resident status, remember that the granting of lawful permanent resident status supersedes that order of deportation that you had in the system. So now you can go back, right, and to the immigration court and terminate that removal proceeding solely because you have been granted a lawful permanent status with USCIS. And that is much easier. As a matter of fact, the BIA, Board of Immigration Appeal, has held that reopening a case solely to terminate that removal proceedings on the basis of being granted a lawful permanent resident status by USCIS is warranted. It means that the court has no option but to terminate that removal proceeding. in the system, right? Terminate, close it, it is done. Then the record will not reflect that. The reason you want to go back, it's because sometimes, not all the time, sometimes at the port of entry, let's say you get granted the lawful permanent status with USCIS and you travel abroad and you coming back with your green card, and the port of entry, of course, the officers look at the record and show that this person was ordered removed long time ago. What they don't understand sometimes that granting of lawful permanent resident status supersedes any order of deportation. Sometimes they don't understand that. Then you be stuck there, try to explain yourself, hiring lawyers, trying to fight for you, and you quite frankly don't understand, well, I have a green card, why they're still like trying to prevent me or denying me entry. It's because in the record it's still showing that you were ordered removed. Okay, now the question is, well, what about if I just start with the court first to try to terminate my removal proceedings? Because that's what we advise people all the time, right? Go with the court, terminate, remove, reopen the case, terminate removal proceedings, blah blah blah. But sometimes you file those motions, especially if it's not a joint motion. Sometimes it doesn't work. Sometimes you be there fighting for them to reopen that case, and they don't. As a matter of fact, TPS holder had the same problem. That's why they sue USCIS, because they were trying to convince USCIS that USCIS had jurisdiction over the case. So they had the same problem trying to reopen the case and terminate removal proceedings, and it was not working. Okay? It works better if ICE is going to collaborate with you and join the motion. And sometimes in some circuit, even if ICE does not collaborate with you, you can just file with the court, and the court will just see that there's a good cause and reopen the case and terminate removal proceeding. Then you go back to USCIS and adjust status. But remember, it's always doesn't work like that. That's why sometimes you take the back door and see if the back door is going to work for you. Okay? Other point is this. The question was asked, and as a matter of fact, this case, we work on that case, and I'm gonna explain to you. So the order of deportation was issued in absentia. Simply means that the person failed to appear in court. Okay. The question becomes, well, can I still go with USCIS and adjust status now that I'm eligible to adjust status? The answer is this. You have to meet the requirement as well for that. First, the order of deportation the notice was properly. So basically, it was issued properly with notice, like it actually went to your lawyer or to your address that the court has on file. So it was served properly with notice, of course. Then it has been 10 years since they issued that order, and you never left the country, never departed. Remember, keyword, never departed. So it means that the order was never executed, right? 10 years later, failed to appear in court, you were issued an order of deportation, it was served to you properly with notice, and you failed to depart the US. Now 10 years has passed. Will you be able to go to USCIS and adjust status? The answer is yes. As a matter of fact, we did that. But remember, once USCIS give you that lawful permanent resident status, my friend, try to go back to the court and reopen the case and terminate the case, because that it becomes much easier because you have the green card already. Okay? So, but remember, because you failed to appear in court, you have a 10 years bar, right? That's why it has been 10 years since they issued that order of deportation. And you have to apply for a waiver with USCIS, because you have to explain yourself why you failed to appear in court, right? It's not just gonna go down that easily. Okay? So, and once you get it, and in our case, our client filed to appear in court. It's a long story. We're gonna come to it another day, but the client failed to appear in court. We had to file with a waiver, and she was adjusting status based on marriage, and marriage is a good faith marriage because they have kids and so forth. So USCIS finally granted that lawful permanent resident status. Well, now we're going back to court trying to terminate removal proceedings because we don't want any problems at the port of entry when she's traveling and coming back, because we don't want somebody to be calling us the middle of the night like, oh, Bijoux, I'm stuck here at the airport, because we failed to properly advise her that it might happen. That doesn't happen all the time, but it might happen that the officer do not understand that the lawful permanent resident status supersede that order of deportation. So yeah, that's why we have to go back to court and make our case and terminate that removal proceeding. As a matter of fact, BIA has already held that it is warranted when somebody has already adjusted status with USCIS. It is warranted that the court has no choice but to terminate removal proceedings. Okay, so this is a very complex subject. You need counseling. Yeah, you do, even if you think like you don't, but you need it if you want to adjust directly with USCIS. You need counseling because we have to determine whether it's a good move or not. If it's not a good move, then we will start with the court, try to convince ICE to join motion to reopen and terminate. But sometimes, really, because of the difficulty that we have, convincing USCIS that there has jurisdiction is much better option. Well, have we filed before? Yes, we filed before to convince USCIS that they had jurisdiction. Then we had to go back to the court and file again and try again until we got it. So there's really no right way to go. It just depends on the facts of the case, okay? And provided that the eligibility requirements has been met as well. So again, you need counseling because this is a very complex subject matter of immigration. And to 275-121-80. If you do not have a lawyer, you can call. You can email me as well, bijoux.ngwandaesq@gmail.com. Again, consultation fees apply. Until next time, bye-bye.